Welcome to our new and improved compliance training. Compliance programs are important for a number of reasons. We have had a compliance program in place for many years, but it has changed over the years as healthcare rules and regulations have been introduced or have changed to ensure that our continued compliance with all laws that impact our operations. Under the Affordable Care Act, compliance program and training is a requirement for all organizations that provide services to individuals covered by healthcare programs. Compliance programs raise awareness in the organization of federal rules and regulations that must be followed and the development of policies and procedures that ensure that the organization remains compliant with these laws. A good compliance program encourages us to report problems so that they can be investigated and resolved. A compliance program also is formal communication of our commitment as an organization to always do the right thing. It makes good business sense, and it supports our own corporate mission and values. In fact, one of our core values, as you all know, is integrity. What are the 7 elements of an effective compliance program? Well, first, you need to have someone responsible for overseeing the program. In most organizations, this is the compliance officer. You need to have a code of conduct and policies that spell out what behaviors are acceptable and what behaviors are prohibited so that employees understand their responsibilities. Education is important. Annual training and periodic educational newsletters to ensure that employees understand the compliance program and their role to ensuring its success. Areas of the organization require monitoring and auditing of activities and processes to ensure compliance with the program. There needs to be a process so that anyone can report an issue or possible violation. If an issue is reported, it needs to be investigated and resolved. And lastly, the program needs to be enforced with consequences for those that do not follow the policies or who violate the company's code of conduct or the compliance policies. Our code of conduct is the foundation of the compliance program. Our code of conduct applies to all employees. All employees must read, understand, and comply with the code of conduct. Upon hire, all employees receive the code of conduct and the compliance program and must sign a certification that they have received and will comply with the program. All employees must comply with all federal and state healthcare program requirements and our policies and procedures. Promotion of and adherence to the code of conduct is an element in evaluating the performance of all employees. Non-compliance will impact your job evaluation and could result in disciplinary action and possible termination. So let's go into the code of conduct, and we're only going to touch upon a few of the highlights of our code of conduct. Some general matters. Since our lithotripsy company is a physician-owned company, at our fixed sites we provide disclosure information to our patients regarding physician ownership. You may have seen the disclosure in our patient consent form as well as in our patient bill of rights, which is also on our website. Physicians will not negotiate business on behalf of the company. Physicians will not receive any payment in cash or kind for the referral of patients. It's illegal and it's unethical to offer or solicit any financial inducement, gift, or other thing of value to prospective patients or others in order to encourage patients to be treated at our centers. We do not disclose any information regarding the number of cases a physician performs to anyone other than the physician himself. The Code of Conduct also touches upon some employment laws. We recognize that our greatest strength lies in the efforts and talents of our employees. We provide equal employment opportunities to current and prospective employees based solely on merit, qualifications, and abilities. We value our employees and will pay employees fairly and will provide a safe and healthy work environment. We prohibit any individual from engaging in any act or any form of harassment of any other individual on the basis of that person's color, race, religion, national origin, handicap, sex, sexual orientation, or age. Delivering exceptional patient care is the core of our mission. We have a patient bill of rights that includes the mandate that all patients will be treated with respect and dignity. All treatment we provide will be medically necessary, and we will make no distinction in the care we provide based upon the ability to pay. All employees will be licensed, credentialed, and skilled at the services they perform as required by law. We will comply with all laws and regulations regarding patient rights and privacy, including the Health Insurance Portability and Accountability Act of 1996, which we all know as HIPAA, the Health Information Technology for Economic and Clinical Health Act, or HITECH, enacted in 2009, and the HIPAA Final Omnibus Rule, which was enacted in 2013. On a periodic basis, through our QI, Information Management Committee, and Compliance Committee, procedures and standards of care are reviewed to ensure that the patient care we provide remains of superior quality and remains compliant with federal and state healthcare regulations. And as previously mentioned, we provide disclosure of physician ownership to the patients who we treat at our fixed sites. If an employee receives a subpoena, an audit letter, or any other communication from the government that requires a response from the company, the employee should give the information requested to the compliance officer or your supervisor immediately. All employees are required to report any contact, inquiry, investigation, proceeding, charge, or complaint involving any court of law or state or federal agency that is related to the company or its operations in any manner. If a subpoena or an audit letter is received, or if we're notified that one will be received, no documents may be destroyed and no emails may be deleted. An important compliance policy is our exclusion screening policy. We screen all prospective employees prior to offering employment, and we screen all physicians prior to granting practice privileges and thereafter on a monthly basis. And an eligible person is defined as someone who is currently excluded, debarred, suspended, or otherwise ineligible to participate in federal health care programs or federal procurement or non-procurement programs. The OIG imposes exclusions for a number of reasons. There are mandatory exclusions. The OIG is required by law to exclude from participation in all federal health care programs individuals and entities convicted for certain types of criminal offenses. There are also permissive exclusions. The OIG has discretion to exclude individuals and entities on a number of grounds, including misdemeanor convictions related to healthcare fraud other than Medicare or state healthcare program, suspension, revocation of license to provide healthcare for any reasons bearing on professional competence, professional performance, or financial integrity. What is an exclusion? Individuals excluded from participation in federal or state healthcare programs, for example, Medicare, Medicaid, TRICARE, may not work in any capacity for a company that directly or indirectly receives payment from these healthcare programs. An excluded company cannot provide lithotripsy services to a hospital. We screen using the OIG list of excluded individuals and the System Award Management, SAM, excluded parties list system. HR performs employee screenings and credentialing screens all credentialed positions. We also check maiden names and other known aliases and request this information on our employment and physician credentialing applications. We use a vendor that provides monthly federal and state exclusion screenings on all employees, physicians, and vendors who provide us items or services used in conjunction with services we bill to any federal or state healthcare programs. Any employee, physician, contractor, or vendor under investigation must notify the compliance officer in writing if the outcome could result in suspension or revocation of his or her license or exclusion from a federal or state health care program. Any person who is excluded, suspended, or debarred from participation in a federal or state health care program or any commercial payer plan or program, whether it's voluntary or involuntary, must notify the compliance officer. Our code of conduct has many standards in place to ensure accurate and timely billing. All coding must be accurate. If it is not documented in the patient's medical record, it did not happen. Billing must ensure that charges are entered for the services we provided and that were checked on the text sheet or encounter form and signed off by the physician. We can only bill for services using the appropriate CPT code. We cannot upcode for services. Upcoding is when a provider bills using a higher paying service than what was actually performed. For example, a physician does a photo vaporization of the prostate but knows that the enucleation code pays higher, so he codes his services using the higher paying CPT code. We follow a messenger model for physician professional fee contracting and ensure that each physician determines his or her own fees for services and all fees are kept confidential. We cannot bill for any drug samples or other free items that we receive. And lastly, all refunds, once identified, will be refunded within 60 days or according to the terms that are worked out with the payer. We make an effort to collect patient copayments and deductibles. Routine waiver of copayments and deductibles is not permitted, and patient balances are only discounted or waived in accordance with our charity care policy. We do not offer professional courtesy. As a physician-owned company, this could be interpreted as an inducement. We are committed to ensuring that our contracting practices comply with federal and state laws, regulations, guidelines, and policies. A hospital may not be pressured to accept contract terms in order to obtain or maintain referrals. A fundamental tenet of both the federal anti-kickback statute and the Stark Law is that items of service are provided at fair market value. A physician may introduce the company representative to a hospital, but the physician must not participate in the negotiation of the contract. We may not enlist a physician to help secure a contract, and physician referrals must not become part of the contract negotiation process. No one may threaten or imply that if a contract is not obtained or renewed, a physician will take his patients to another facility. In most instances, services should not be provided unless a written contract is in place signed by both parties. For laser services, we must document our attempts at obtaining a signed agreement before we provide any services. We have a process for legal review of our agreements to ensure regulatory compliance. Our code of conduct and our policies guide us in our interaction with our physicians. We may provide refreshments and modest meals at a meeting to market our services to physicians. No other entertaining of physicians to market services is permitted. We cannot take them to the masters, we cannot fly them to vacation resorts for meetings. Other than logo pens or mugs, we cannot give gifts to our physicians or facilities to market our services. Payments or other items of value provided to physicians must be carefully tracked and may need to be reported. We are a physician-owned company and have strict guidelines that must be adhered to regarding physician investment in the company. Only urologists may be offered interests in the company. There can be no requirement to use the services in order to invest. There can be no requirement to divest if the physician does not use the services. Interests in the company must be sold at fair market value, and likewise, interests must be redeemed at fair market value. When a new company is formed, physicians must invest enough to sufficiently capitalize the company. And lastly, we avoid pro formas that may appear to exaggerate the rates of return. We may hold meetings with physician investors to discuss company business, to discuss or present new therapies, new business opportunities, but we may never entertain physicians for the purpose of rewarding or inducing their referrals to the company. We may provide refreshments or sponsor a dinner to make a pitch to a potential investor. The value of the meal shall not exceed $100 per person. No other thing of value, such as bottles of wine, gift cards, gift certificates, may be provided to potential investors. No spouses or guests can be included other than the office staff member that is involved in the topic of discussion. For instance, if there was a meeting to talk about scheduling, the office manager could attend that meeting. Any payment or item of value provided to a physician needs to be carefully tracked, and it may be required to be reported. We can never offer, ask for, pay, or receive anything of value in return for the referral of patients. For our facilities, we should not make gifts to or accept gifts from hospital personnel. Items of nominal value at the holiday time, they are allowed. On rare occasions, we may take administrators of healthcare facilities to lunch to discuss contracts. Entertainment by hospital personnel should be done in consultation with the compliance officer. All employees and physician investors must report to the compliance officer any suspected or potential violation of any federal healthcare program, violation of our code of conduct, violation of policies and procedures, violation of any federal, state, or local law or regulation. The compliance officer or the compliance committee will investigate all reports. Our disclosure program. To report concerns, you may contact me with my email or my office number or by my mobile number. Our disclosure program provides that there will be no retaliation or retribution for anyone who reports a problem or concern. We want to hear if there is a problem. Most things can be resolved. It's easier to resolve an issue earlier when we hear about it than later when it's a problem. Report any attempt at retaliation to the compliance officer. Anyone that's retaliating will be disciplined. You have different reporting options. We have a hotline, a toll-free number, so you could report anonymously, or you can use the hotline and report with your name. You are welcome to report anonymously, but it might be more difficult to investigate if you do. If you do report anonymously, give as much information as you can. If you get more information, call back and make another call. We will make all reasonable attempts to keep your report confidential, but sometimes the context may reveal your identity. We will protect you against retaliation. Okay, now let's look at some of the compliance policies. We're just going to go over the highlights that support our code of conduct. There are several areas in the company that we may encounter compliance concerns. The first is a conflict of interest. We all know that conflicts of interest occur when decisions or actions regarding patients are influenced by personal or professional interests. Some instances that potentially could give rise to a conflict of interest. When ordering supplies, we should purchase supplies based on established criteria, price, quality, and service. We do not accept gifts or services or entertainment or other items of value from a vendor. These may impact your decisions. Use of the company property and assets must only be used for legitimate business purposes. Upon hire, every employee receives a copy of our confidentiality, non-compete, conflict of interest policy, and an agreement that they sign certifying that they have read and understand the policy. On an annual basis thereafter, all employees reaffirm their continued compliance with this policy. Because we have physician owners, as I mentioned, they are required to disclose their ownership in any treatment site where they are referring and treating their patients. This is their obligation, and they will often disclose their ownership when they are discussing patient treatment options. As I previously mentioned, we also provide this disclosure to our patients of their physician ownership in our patient consent form as well as in our patient bill of rights. We let patients know that they have the right to choose their provider and the facility location. Physicians may not treat patients differently if a patient does decide to go to another facility for treatment. We respect our patients' right to privacy and confidentiality. These rights are not new, but with HIPAA rules and regulations, there are penalties for violating a patient's right to confidentiality. We adhere to all HIPAA privacy and security rules. We have separate training for new hires, and all employees get annual training on HIPAA rules and regulations, so we're not going to cover those in this training session. But we do know that to protect our patients' privacy, only staff who need to know PHI to perform their jobs have access to it. We grant access to PHI based upon a person's job function. We also limit the information necessary to perform the job. This is referred to as the minimum necessary standard. We ensure that all records containing PHI are locked and secure. Only those staff members who need the information for treatment, payment, or healthcare operations are authorized to access the information. In patient treatment areas, computers must be turned away from public view. PHI must be properly destroyed. We have bins for shredding paper PHI. And we use encryption technology when we send any emails that contain ePHI. Our interactions with our payers demonstrate our commitment to our contractual obligations, as well as our shared concern for quality, efficient, and cost-effective care. We should accurately code and bill for our services. We assure that all billings conform to pertinent state and federal laws and regulations. We should not present any claims for payment that are false, fictitious, or fraudulent. These could violate the Federal False Claims Act. The False Claims Act makes it illegal to knowingly present or cause to be presented a false or fraudulent claim to federal health care payers such as Medicare and TRICARE. Many states also have False Claims Act. Illinois is one that does.
There you go.
It prohibits knowingly making, using, or causing to be made or used a false record or statement material to getting a claim paid. Knowledge in this case means actual knowledge, deliberate ignorance, or reckless disregard. Claims may be false if the service is not actually rendered to the patient. If it's provided but already covered under another claim, is miscoded, or is not supported by the medical record. For example, if we submit a claim for treating a stone and the medical record didn't document the presence of a stone, this would be considered a false claim. We have touched upon compliance concerns with contracting before when we discussed our policy to not have any physicians involved in our contract negotiations. In addition, we must ensure that our contract payments are at fair market value price. What is fair market value? Fair market value is the value in arm's length transactions consistent with the general market. The general market value is defined as the price an asset would bring as a result of a bona fide bargaining agreement between well-informed buyers and sellers who are not otherwise in a position to generate business for one another. We determine fair market value by using an independent third-party appraisal. For contracting compliance, we have procedures for contract approval, legal review of agreements as needed, and a process to track the various components of our agreements. For example, the effective date, the term of the contract, the services that are provided. We also ensure that payments are made according to the contractual rates. In some instances, it is acceptable to reward those who refer business to you. However, asking for or receiving any remuneration in exchange for the referral of federal health care program business is a crime under the federal anti-kickback statute. The anti-kickback statute applies to both payers and recipients of kickbacks. Just asking for or receiving a kickback could violate the law. The federal anti-kickback statute prohibits the knowingly and willfully soliciting or receiving any remuneration, directly or indirectly, overtly or covertly, in return for referring an individual to a person, and that includes a hospital, for the furnishing or arranging of any item or service for which payment may be made under a federal health care program. Violating the federal anti-kickback statute carries stiff penalties, which can include fines, prison time, and program exclusion. What is a kickback? Kickbacks can be cash for referrals or more subtle kickbacks, like free rent, below fair market value rent, free clerical staff, or excessive compensation for medical directorships. Numerous physicians have been sanctioned for selling their product loyalty to drug or device companies or other vendors. What types of arrangements can potentially implicate the anti-kickback statute? It doesn't mean that they do, but often they can. Payments in excess of fair market value. For example, we pay hospitals more than it costs for leasing the staff or the space. Payments that are lower than fair market value. Payments for items or services that are not legitimate or are not necessary. For example, we only need one room to perform our services, but the hospital leases us 2 rooms, and we pay them for more space than necessary to provide those services. Payment for referrals. The hospital pays us more than the fair market value for lithotripsy because we tell the hospitals that the doctors will treat all their cases at the hospital. Selective opportunities to invest. For example, we only offer investment interest to those physicians that treat the most patients with us. Payments that would vary with the volume or value of referrals. For example, we would pay our physician investors not based upon the percentage that they own of the company, but based on how many cases that they treat. Threats to take patients to another hospital or facility. Promises or assurances that a contract will result in referrals, promises or assurances that a physician will refer patients for other services. Gifts such as expensive bottles of wine, sporting event tickets, expensive dinners, and lending the use of the vacation home. Another area of our compliance policy involves patient identity theft. In 2008, the Federal Trade Commission, or the FTC, along with the federal bank regulators and the National Credit Union Administration, adopted regulations implementing a new federal law, which is commonly known as Red Flags Rule. The Red Flag rules require creditors that oversee or maintain covered accounts, which we do, to adopt a written identity theft prevention program, to detect warning signs or red flags of identity theft, to take steps to prevent the crime, and to mitigate or alleviate the damage it causes. Our billing office and our front office registration staff receive training on our patient identity theft, red flags, rules, policies, and procedures. Okay, we've talked about the code of conduct, we've touched about some of the specific compliance policies. Now we're going to just elaborate a little bit of the highlights of our overarching compliance program. We have a compliance committee with the following responsibilities: to advise the compliance officer, to assist with implementation and maintenance of the compliance program, to work with staff to develop standards of conduct and departmental policies and procedures that promote adherence to the compliance program, to identify areas of high risk to continually audit and monitor, and to participate in our quarterly compliance committee meetings. We have two main areas that we audit. One is an operations audit. Every quarter, an audit of 70 patient charts are reviewed for accuracy, for completeness, for adherence to Joint Commission standards, and for regulatory compliance. We aim for a score of greater or equal to 95% compliant. Staff with ongoing deficiencies are given further instructions and are monitored for improved compliance. The medical record is compared to the encounter form to ensure accurate billing for our services are completed. The billing office also audits the same 70 patient records to ensure proper billing of the procedures performed. The focus of the billing office audit is to look at the text sheet, to compare it to the charge batch for accuracy, to ensure that the correct physician was selected for charge entry, reviews the insurance claim rejection reports for error rates or to identify any patterns, and site invoices are audited for accuracy, and the explanation of benefits is audited for correct payment posting. What's the difference between ethics and compliance? Well, ethics is bigger than compliance. Compliance is doing what you are required to do by laws or rules, but we want our employees to act ethically too. Ethics is doing what you should do because it's the right thing to do. We've always had the mantra, always do the right thing. To quote Mark Twain, it's never wrong to do the right thing. So use your ethical compass. Stop and see if there's a problem. Ask yourself, why is it a problem? Is it legal? Is it ethical and consistent with our values? Am I being truthful and honest? Does it follow company policies? Can the decision be deferred to others? How would it look in the newspapers? Is it in the best interests of the patient? When you're in doubt, what should be done? Just ask. And that concludes our training.